I think we can get started. So welcome to the webinar, and here we go. So the first thing that I always do as a lawyer is that I got to give you guys a couple ground rules, some caveats, okay? Namely, today's discussion is general information. It's not legal advice. We'll be talking about the rules and exceptions to the rules and things that come up very typically. Okay, but those rules have exceptions, and then even the exceptions have exceptions. So it may not be applicable to your situation. And what you really need to do is get competent legal advice, whether it's me or somebody else. Um, throughout this program, we're going to answer some of your questions, and we're going to also get to some of them at the end. And those aren't also, those answers are not going to be legal advice either, okay? Spending 10 or 15 minutes with you is not going to be enough to give you the kind of advice you need to make a good decision. So with that in mind, let's get to it. So I always like to start these presentations first by letting you know what it is that we're going to do. And so we're having a little bit of problems here. Let me just kind of ping down here. I like to give you a roadmap. So first we're going to talk about my backgrounds. We'll talk about sort of the big picture and the process that's involved here and some common pitfalls, and then we'll get to your questions at the end. I think now is a good time to sort of talk about, who should be watching this webinar and, who's going to sort of get the most value for it, and also who will continue to get value if you're sort of outside that scope. So obviously, there's probably the most value associated with somebody who's thinking about selling his or her business. And so, that's sort of what this webinar is geared towards. It's not meant to be, a replacement for hiring a lawyer and working with a lawyer, and it's not meant to be a class to teach you how to be an M&A army in 40 minutes to 60 minutes. That ain't going to happen. But I think you should get a fair amount of value. It's going to go over the process and the procedures and the things that are involved and what you can do to really sort of help position yourself to sell your business. Now, if you're not selling a business, you can still get a tremendous amount of value here. And the reason for that is that, if you've either are thinking about selling a business thinking about starting a business, or you've started a business and maybe you're thinking about selling it, but you're not quite there yet, I think it's always important to get a sense for where it is that you want to go or where you'll end up, and then you can work towards it. So what does that mean? Well, basically, if you're a business owner, we all exit the business at some time. Okay, whether that is, by your choice, because you sell it, or you take it public, or it's time for you to retire, or not by choice. You die, you get a hostile takeover or something else. So if you want it to be on your terms, I think it makes the most sense to try and build something that somebody else is going to want to buy. Or at least invest in. And this webinar is going to help you do that. It's going to help you get a sense for what the sale process is, so that you can kind of target and begin to think about how to position yourself for a little bit later on. So let's start with my background a little bit and give you a little sense of who I am and why we're hosting this webinar today. So I'm a corporate and securities attorney. I've been practicing law since 2005. I've acquired a fair amount of gray hair at this point, which is always fun. I think it helps me now. I didn't like it when I was younger. And actually, I want to just take a quick second, and I see that Bradley cannot hear. Bradley, can you still not hear me? If not, you can try dialing in by your phone. Okay, well, hopefully Bradley will be able to resolve that, but I think that's just one. So I've been practicing law since 2005. I used to work for a very large technology-focused law firm. Wilson Sonsini is the name of the firm, and it does a lot of technology transactions. And I actually did a number of things for them, including litigation for them, which was a fantastic experience. But I wanted to focus my practice on the corporate needs of emerging growth companies. basically startups and other, small and middle market businesses. So I left. I started my firm coming up on 5 years ago, and we're based here in San Francisco. But we work with companies that are throughout the world, actually. But the commonality that they all have is that they do some business in California. Currently, it's me and another very experienced attorney, and then we have an assistant, Alan, who is the plant in the audience, if you will. So if you see any questions from him, they're softballs, but we love them anyway. So let me tell you a little bit why I'm doing this. I love working with entrepreneurs. We typically do that as outside general counsel, which means basically we get to help them with, filter and resolve all sorts of legal issues, whether it's corporate or securities or employment or IP. Either we get to sort of act as the first stage, the quarterback, if you will, figure out what those issues are, and if it's something we handle, we work on, and if not, if it's so more efficient for someone else to do it, we make sure we get them connected to the right people. I consider myself an entrepreneur. I left a big firm because I wanted to start my own thing, and so I think I really share that with our clients. It's something that's pretty special. I love the energy that they bring to their projects, and I think that we bring the same energy too. And as a personal note, outside of law, I skydive. I'm a competitive skydiver with over 1,200 jumps, and I think actually I just got back from nationals. We won second place, losing to the Air Force, which is a little bit sad, but those guys are pretty well funded. So, I mean, I think, as an entrepreneur, I'm able to understand the passion, and also as a skydiver, I think that it helps you, one, with the passion, and two, with the understanding of risk allocation and what it takes to really sort of prepare yourself to deal with the unknown. So I think that's what makes us a good fit for a lot of folks, and what sets us apart from a lot of our competitors, both that are our same size and that are also much larger. So let's continue to move on. Let's talk about what I consider to be the big picture. Why are you doing this? Where does it sort of fit in? Because I know that I'm sure we have folks on the line that have built businesses and they're currently running them, but I'm sure we also have some folks who are, just starting out, or they're just thinking of starting out. So this is there's a little bit of a tired graphic here. I've had it for a while. I'm looking for a graphic designer, so if you know a good one, feel free to send me an email, and maybe we'll hire them. But I think the big picture is here, right? So you have your company, and it is represented by this box in the middle. And the point is, you're going to be putting inputs in it and get that box to grow. All right. And the inputs are going to be, capital, which is going to come from your investors, ideas, which are intangible assets, and then you'll be putting in services and technical components. So you'll have people in sales and marketing and the engineers to actually put and build out this idea, because a company is ultimately a set of relationships between people. Sometimes those relationships are, hopefully most of those times, are memorialized in contracts. But that's what it's about. It's about putting together this machine, but it's not really a machine. I don't use it in the sort of hardware sense. I mean it in terms of relationships with people, and some of those people may interact with hardware, but that's where the value is. It's in that set of people, the core competency there. And so hopefully, as you continue to put in all of these relationships and you get them memorialized, it's going to grow in value. And then at some point, you're going to want to realize the value that you've created. And when I say realize, I mean you're going to turn that value to cash or stock in an acquiring company, or any number of other things. But for those of you who are entrepreneurs, you're probably familiar with the concept of sweat equity. And what happens is you put in all of your work and effort, and maybe you start drawing a salary, which is fantastic, but most of your wealth is probably locked up or in the company itself. So you're looking for cash out, or what we like to call liquidity, just to bring it back sort of to the title of this program, Make It Rain. That's what, sort of play on words there a little bit. Um, and there are a couple ways to do that. Typically, you hear a lot about initial public offerings, IPOs, and that is one way to do it. But those are farther and farther between. I got another slide that's coming up that'll show you just sort of the relative scale of IPOs versus mergers and acquisitions. But another way to do it, it doesn't get as much hype, is an M&A event. Either you get acquired, um, or you merge with somebody. And so that's on the sell side. On the buy side, there's two sides to every coin, right? So, for there to be an M&A event, there's got to be a buyer and there's got to be a seller. The perspective of the seller is that they want to get cash or some sort of other valuable property. The buy side, they're looking for other things, right? They want to maybe be able to step into an existing business already, or maybe they want to grow a larger business. Acquiring another company makes it easy to expand. I mean, both geographically or organizationally. I mean, there are other reasons too, which is that maybe they want to pick up a new piece of technology, or maybe the company they're acquiring has a new customer base, or they're, um, you know, they want to purchase. Sometimes, especially for large companies, they want to purchase either their suppliers or their sellers, so they get what's called vertical integration. You can think about Apple. Apple doesn't necessarily outsource. Um, well, they may outsource the fabrication of their computers, but they don't do that for everything, and they're famous for wanting to have vertical integration, right? That's why they write their own software. That's why OS X is written by Apple rather than Windows. As compared to like IBM. Kind of think about that. Um, on the buy side also, sometimes they're investments, or investment by private equity. And I'm kind of talking, I know this is geared more towards the sell side, but the reason why I'm talking about the buy side is kind of like any sale. You got to know your customer, you got to know what it is they're interested in so that you can target and focus what it is that you're doing, and to a certain extent also make sure that they are getting the information that they need to know in order for them to make the decision that works for them. So I think that's helpful. So let's talk a little bit about IPOs versus mergers and acquisitions. And in the meantime, I'm just going to scroll down and see whether or not there are any questions. And here we go. So you can take a look here at sort of the relative scale of IPOs. This is sort of the nominal value of IPOs versus mergers and acquisitions in 2013, 14, and 15, and a little bit into 16. So you could see that there were roughly in 2013 50 tech companies for 12 billion versus $94 billion worth of tech companies were sold in 2013. You can see that the number increased to 50 billion in 2014 for IPOs, but that's still less than 1/3 of all the M&A events that happened. And then the same thing also for 2015. So you can see, in terms of scale, the M&A market is much, much larger than the IPO market. So let's talk a little bit about the process. Excuse me, I think we just skipped a slide. Hold on one second. That's right. So there are many different, we're going to move into the process at this point. There are many different types of transactions, okay? And this is one of the things that, the first thing that we start to educate our clients about is the different options or mechanisms for doing this. And let's take, for example, a corporation. And I'm going to just give you a little bit more background about how a corporation is sort of set up, to make sure that we're sort of all on the same page here. Right, so you have, let's just take Apple, for example, right? You have Apple. Um, it has its stockholders who are the owners of the corporation, and um, they have the right to receive dividends, and they have the right to vote on to elect directors. And then the directors, they sit on the board of the company, and they are the individuals who work collectively to make the decisions on behalf of the corporation, sort of the long term, sort of medium to long term decisions, and set both where the corporation is going to go as well as what it's going to take to get there. And then you have the executives, you have the CEO, the COO, any number of presidents, vice presidents. Those individuals are the folks who are charged with carrying out the decisions of the board of directors. So sometimes maybe you'll hear, a president or CEO say, well, I got to get approval from the board for this or that. That's what they're talking about. And I bring that up because, it's helpful to think about that in terms of which different type of transaction you choose to do. Whether it's going to be a statutory merger, which would involve typically setting up another company and then having the target company merge into that, or a stock purchase, where you would have somebody come in and acquire all of the stock of, in our example, Apple's shareholders, or if you're going to set it up as an asset purchase. And we'll talk a little bit more about these things a little bit later, but an asset purchase is basically where you're going to pick up and you're going to acquire just the assets that you're interested in. So what are assets, right? I mean, they could be, let's say you're acquiring like a trucking company or something, right? I mean, it might be, the actual physical trucks themselves. It might be some of the labor relationships and agreements that are in place. But you wouldn't actually be buying the company, you'd just be buying assets that the company had. So move a little deeper into the process. Let's talk about the process as it relates to you. And this is like so important, because folks will frequently wait until too long to bring in experts, whether they are attorneys or bankers or accountants, and as a consequence they may have positioned themselves incorrectly. And so knowing this process and knowing when to get people involved is really going to help avoid a lot of pitfalls. So the initial and so the way that I do this, I break it up into a few stages, right? I normally say the sort of preliminary process, and then we move into the letter of intent stage, and then we move into the diligence stage, and we move into the drafting of the definitive agreement that takes place at the same time as the diligence, and then there's the signing, and then there's the closing, and then there's post-closing action items and integration. And we're going to give you an overview of all of that today. But I wanted to just give you a top-down picture before we start zooming in on these. So, to a certain extent, I think the preliminary process is one of the most important parts, and certainly one of the most overlooked parts. That's because usually when folks come to this, they've maybe already talked to somebody who they're going to be potentially selling their company to, or kind of already started to put down psychological expectations of how the deal is going to go before they know whether or not it's even going to be a good deal for them. And one of the issues with that is that at the end of the day, buying and selling a company is about people and relationships. And everybody probably from their day-to-day life has experienced, when you start setting expectations, people get stuck on them. They're going to think that that's the way that it's going to go down, and if you want to change expectations, it's kind of harder to do that once it's already gotten put in place. So in the preliminary process, frequently what we see is, some maybe preliminary discussions. Okay, maybe you have a company that produces some software and it sells it to another company. You have an exclusive buyer, right? And they want to hire you guys, they want to bring in your team. That's something that we see from time to time. Maybe maybe you're at a trade conference and somebody sees you and they, and they like what you're doing and they want to pick up, the product of your company. Um, some of these preliminary discussions kind of happen, and maybe you get an unsolicited offer. The other thing that comes up, and when you get that, I think it's helpful to move into what I call like the deliberations, right? I mean, it's to sort of think about it, assemble your team to figure out whether or not that is the right decision for you and for your company. And when I say that, it's usually involves, especially for companies, um, assembling and talking to the board. Thinking about what the value is to the shareholders if you move down this path. And in doing that, you're going to need to gather some experts. You're going to need lawyers and bankers and accountants and strategic advisors. And the reason for that is depending upon how you structure the deal, it makes a big difference in the long-term outcome. Okay, so for example, and this is not meant to give you any tax or legal advice, but generally, sellers love to set up um, either stock purchases or certain statutory mergers, so that the effect on their shareholders is that they are subject to capital gains tax as opposed to other kinds of income tax. Buyers love asset deals, okay, because asset deals generally, but not always, but asset deals have usually the benefit of leaving the liabilities of the existing company behind. Okay, what could some of those liabilities be? Well, they could be anything. I mean, we've worked with some manufacturing companies, and maybe there are environmental issues. Okay, maybe there's some concern that waste may not have been disposed of properly. Um, there may be some, although there are also some other laws around that where the liability may attach with you, but there may be some employment issue that has come up. Perhaps the company is getting sued for harassment, or it might be likely they get sued for harassment or discrimination. Maybe somebody slipped and fell, going down the stairs, and so there's some sort of personal liability issue. Or so that's generally why, at least from a buyer's perspective, they like asset deals. Um, and so if you've not consulted with your experts like lawyers, if you haven't talked to your accountants, um, you may not know, what the tax issues are going to be, what the liability issues might be, and how that might sort of affect you sort of long term. Bankers really fit into this picture too, depending upon the size of the deal that you're doing, because they can help you determine what the value of your company is, and also potentially also help you determine who potential buyers are. And so, how do they value the company? Well, it sort of depends. I mean, there are a few different ways that they take a look at it, but they can look at comparables. They can do discounted cash flow analysis, sort of things like that. They can take into account if you're going to be selling it to a strategic acquirer. So let's just say strategic acquirer in the I don't know, let's just take like a trucking company or something, right? If you were going to, we did a truck deal, a deal that involved trucking not too long ago. I guess that's why it's on my mind. But let's just say that you make trailers or something, right? For semi trucks, and there's a company that makes the actual rig itself. Well, I mean, maybe they want to pick you guys up because they haven't been doing that in-house and they want to do that. Maybe they'd be willing to pay a premium for it because it helps them with their long-term growth. That's kind of where bankers will fit into the picture, and why they make sense to get them on board. And we'll talk a little bit more about onboarding bankers later. And then, there are also strategic advisors that hopefully you have with your company. Maybe they're folks who are either on your board, or maybe they have an advisor role to the board, or maybe they're consultants. And getting those folks together too is really important because they'll help you identify both the near-term and long-term, value of the company and where selling your company and to whom you'd sell this company to, where you could get the most bang for your buck, so to speak. So the other thing that comes up in the preliminary process is non-disclosure agreements, NDAs, and exclusivity agreements. And those agreements are pretty critical. And, I can't tell you the number of times, especially, I mean, I love startups, but I can't tell you the number of. But the one thing I find a little perplexing about them is that, and I can understand it from a cash flow perspective, they kind of wait too long to see their lawyer. So I've definitely had clients who've come in before and they have executed an NDA and maybe even an exclusivity agreement, meaning that they can't go out and shop this other deal around before talking to their experts or before actually working through some of these issues. And they kind of lock themselves up. And we'll talk a little bit more about the pitfalls of doing that in a little bit. But those are real things and real issues, especially with the exclusivity agreement. If you have a company and you're not the sole owner of that company, let's say you have other shareholders, you're going to have potentially fiduciary duties to those shareholders to maximize the value of their shares. And one of the really big issues that comes up is that if you sign an exclusivity agreement too soon, you may be effectively locking yourself into a deal which might be less than if you didn't execute that exclusivity agreement. So how does that actually play out? Well, basically, you can think of this concept. You're only as hot as the number of people that want to buy you, right? So if you've already got one person who is interested in you, you can almost be certain that you can go out to somebody else and get a better offer, and you get to basically play those guys or gals against each other and get a much better value for your shareholders. So exclusivity is not something to be overlooked. I know it is so hard when you've put in so much time and so much money and watched something grow, and you felt potentially like you will never get a return from this effort. And somebody all of a sudden offers you something that looks fantastic. Maybe it's 10, maybe it's 20, maybe it's $100 million, and you feel like it's the most money in the world. But that may not be the only buyer out there for you. So you got to be wary there. And I'm just going to pause for 1 second and take a sip of water, so bear with me. All right, so we're back. Let's move into a little bit more of the process. So bankers, all right, we've actually I think we just touched on all of these things. So look, bankers are pretty important. One of the pitfalls that we often see is that bankers' engagement agreements, like almost any other agreement, is negotiable. Frequently, although not always, they'll work basically on commission. So figuring out what the commission is, when they've earned it, those are all things that it makes sense to work with your counsel on to make sure that you're getting a good deal with your bankers. Another thing on bankers, just like lawyers, is you really want to make sure that, or just like any other professional for that matter, you really want to make sure that you are going with somebody who has both experience in that area, but then also a passion to serve as, not just your company, but also in that area. So one, they have, the expertise to move a deal efficiently, and then two, they have the passion to drive the project forward, because that's pretty crucial. And let's kind of keep humming along here as I don't want to run out of time. So earlier I talked about the process, the letter of intent stage, the diligence and negotiation of the definitive agreement, and we're going to move through each of those as we're coming along. We'll talk about, the signing of the definitive agreement and then closing and post-closing issues and items. All right, so letter of intent. My goodness, if I had a penny for each time I got one of these things after it's already signed, I would not have to practice law again. But, the letter of intent, it lays out basically the overview of how the deal is supposed to go. I mean, the point of the letter of intent is generally not to be binding, and we usually structure it as that, although there may be some binding provisions in there, which we'll talk about in a moment. But it sets the roadmap for the transaction, and it sets people's expectations. I mean, I'm pausing for a moment because I think, as I've said before, I want to really hammer home that setting and managing expectations is so crucial. So you really need, it's not something like, while it may not take that long to do, and, a letter of intent may only be 2 pages long. It's going to be setting the way, potentially setting the way that the deal is going to go for, you know, the way the deal is going to go, and how much time you're going to have to put into it. And that's true whether it is a, $100,000 deal or a $100 million deal or a $1 billion deal or beyond. It's so critical to get that right. And, when I say that it sort of sets the expectations, it involves the structure, okay? Whether it's an asset agreement, or excuse me, asset purchase agreement, a merger, a stock purchase, which we talked about later. It generally includes some of the big ticket items like the purchase price and how that will be paid, whether that's cash or stock, whether there'll be any earnouts. Okay, an earnout is something where, you may not get all the consideration up front. The buyer wants to make sure, usually earnouts are used when it's kind of hard to tell, is a company, just pulling some numbers out here, $25 million or $30 million. And the seller says, of course it's 30, and the buyer says, oh, it's really 25. And, there's a mechanism in there so that, based on how the performance is over the next year or 18 months, additional consideration will be earned. It talks about some of the more mechanical things like, who's going to be drafting the definitive agreement and what the diligence process is going to look like. And if you haven't already touched on the exclusivity period, that probably be in there too, but there may also need to be things called fiduciary outs. And the fiduciary out goes back to what I was talking about earlier, which is that, you have a duty to maximize the value to your shareholders, or to your other investors. And so, you may need to be able to take that deal. You may need to have the ability to not do that deal and do a different deal if that other deal just happens to present itself. Some other things that go in there are breakup fees and attorney's fees, and then confidentiality if it isn't in there. And all this stuff is really important. Some of it is boilerplate, but as I was telling a client the other day, you may consider that boilerplate, but I'm a lawyer and those things mean things to me. And the judge is a lawyer too. So it's going to mean something to him or her. So really, really crucial to take the time to work on this, with your advisors, make sure that's right, and then get board approval. And I see there's been a question about whether or not the slides will be available somewhere. Yes, we're going to post them on our blog page after the presentation. And they should also, I think, be available as a PDF in the handout. So if you click on your handout tab, it should be there. So let's move on to sort of the diligence process, which, assuming you get through the letter of intent, you'll move into that and the negotiation of the definitive agreement at the same time. But before we do, let me just pass on a piece of advice on letters of intent. It is important to put the time and effort into it so that you can establish the roadmap that you want, because there is nothing more expensive, both in terms of dollars and in terms of emotional energy for yourself, and then also your company as your employees learn there might be a deal going on, than actually moving past the letter of intent stage but having it fail, having the deal not go through. So if the deal isn't going to go through, you want to know that sooner rather than later, so you can skip the time and the heartache and the expense that's associated with it. And that's in large measure because the diligence phase is next. And what is the diligence phase? It is the opportunity for the buyer to know what they're getting. It may look like a Corvette on the outside, but is it really a Ford Fiesta's engine on the inside? It's their opportunity to take a look under the hood and to comb through the company. And I can tell you, we've worked many deals. Some of them there's not quite as much diligence. So, for example, maybe the person who is buying the business has worked in the business and has been, the manager for the last 20 years, and they know the ins and outs of that business better than the owner does. Okay. In that situation, you may not need to do an exhaustive review because they already know it. Um, but if it's somebody completely on the outside, if I could just kind of bring your mental picture back to my diagram at the beginning, the value of the company is all of these relationships and making sure that they've gotten tied in place and making sure that there aren't these liabilities on the outside. So they're going to want to comb through your corporate books and records. They're going to take a look at your IP. Okay, they may review your patents, your copyrights, your trademarks. If you're a software company, and we work with a lot of software and VR companies, they may want to take a look at your code. One of the issues that comes up is open source, whether or not there's any open source software in there. And, many companies use it in development, and that's legit. But one of the problems is depending upon the kind of code that you have in there, those open source software licenses may require that you publish or you can no longer keep your code proprietary. Well, if the company who's acquiring you is in the business of selling their software, that could be a problem. Now, there are ways, that can get fixed, but that's what they're looking for. They'll be looking to see if there are any employees issues. Is everyone properly? I mean, the big one is whether or not people are classified as a contractor versus an employee. Tax issues. Have you been paying your taxes? Have you been collecting sales tax? Okay. Um, we've worked deals and I've litigated deals where, I didn't do the deal on this one, but there was an issue with the company not collecting its sales tax, and there was potentially hundreds of millions of dollars of sales tax liability, once you included the tax and penalties for all 50 states. So, the diligence process is an opportunity for the buyer to take a look at under the hood. But if you're the seller, there's still work for you to do because you want to know what the buyer is going to see before you present it to them so that you can, you know, position yourself and be ahead of it, so you can build that trust that you're going to need to be moving forward. All right, not to, I don't want to run too far over, so let's keep moving on. Let's move down to the definitive agreement. Okay, so definitive agreements generally follow the same format, whether the deal structure is an asset purchase agreement or stock agreement or otherwise, right? And then sort of the main things that are in there are who the parties are, what the structure is, what the consideration is going to be, right? That's, the cash or the stock that you're getting. The mechanics of the deal, when's the deal going to be closing? Where will it be at? Will there be any earnouts? Um, Representations and warranties, and these are so critical. Reps and warranties are basically statements of fact that the buyers want the sellers to make, indicating that something is true or is not. So, for example, let's say, um, I don't know, let's say you're a medical device manufacturer or something, right? And you make these implants that fasten to bones or whatever to help people heal. Um, you want them to the buyer would want them to, disclose and represent that there are no, there have been no lawsuits because, they've been defectively manufactured or defectively designed, right? They used plastic instead of steel, or there was an issue with the steel, something along those lines. And, um, you know, those are going to be statements of fact. And if they're not true, the buyer is going to have a right to damages. They're going to have a right to recourse. Now, if something can't be true, we're certainly not going to advise you to, lie. But what has to happen is that if that issue needs to be brought up and disclosed to the seller, and then that ends up into what's called a schedule of exceptions, which takes some time to do. Covenants are basically contractual promises. Conditions to closing. All right, maybe you've moved through the diligence process, and the buyer does not feel comfortable with the way that certain people are classified. Well, maybe they will have them in the window between signing and closing, one of their conditions to close is that you've got to, move Harrietta over to be an an employee, and to get her to sign off on any back wage issues. Okay, I mean those types of things come up from time to time. Other things that go in there are termination fees and provisions. So, basically if the deal doesn't go through, who's going to bear the cost? Is it each side going to have their own cost, or, is potentially one party going to have to pay the other party some money? And indemnity, getting to the issue of whether or not there are breaches of reps and warranties or there's some sort of other issue. Hotly negotiated, both at the letter of intent stage and then also in the definitive agreement from time to time, are escrows. Okay, is some of the money or some of the stock or some of the other consideration going to be set aside as in a fund, and when will that be released, and how will that be released, and what will it cover? All of those things. So, and then of course the miscellaneous stuff. Choice of law. Is it Delaware law, California law, or something else? And if there's a dispute, where would that be? Would it be here in San Francisco or somewhere else? And then other really important things like how attorney-client privilege gets handled. And this issue is a little bit beyond the scope of the presentation, but ordinarily, and this is a hot issue, ordinarily, if you sell a company, the attorney-client privilege goes with the company. And the problem is if you're the seller, you may not want to be selling and disclosing your communications with your lawyer. So figuring out how to handle that is a super hot issue. And I'm going to move on to the next one. And I see we've got some questions, but we're running just a tad short on time, so we're going to move. We're going to keep going, and then I'll circle back to the questions. So we talked about we've talked about the definitive agreement. Let's move on to the process. So pre-closing, look, you got to get, frequently you'll need to get shareholder approval. You'll have to get potentially dissenters' rights. So those are shareholders who don't want to come along. There are other issues that come up too, like whether they're, this actually comes up all the time. Whether or not some of the agreements that you have in place need to be consented in order to sign them over. So what the hell does that mean? Well, I don't know if you've probably leased property at some point before. And this is just an example from real estate, right? There's normally a provision in there that says, you can't assign this contract. Basically, you can't put another tenant in there without the approval of the landlord or something along those lines. That's the type of issue that's up here, is whether or not you have any agreements out there that are important or key, and that you need to get somebody else's permission before you'd be able to give them to the new owner. So closing, closing is like the best day ever, generally. You've normally worked really hard, weeks or months on this deal. It's, maybe been contentious at time, but closing is the day basically when the documents, the definitive agreement, signing happens at the end in the sort of pre-closing stage, and then closing is when the deal actually gets done. Now, sometimes there's a gap between sign and close, or sometimes they're simultaneous. But when you close, it is the best day because you've been working so hard, and you finally come together and you've now, sold this company. So that's pretty fantastic. With that and then post-closing stuff, there are typically filings that have to happen at the state and the federal level, and then some other things that need to get taken care of in terms of, finishing out the notice and appraisal rights issues that come up. And then the really big thing, which I should have probably made much larger in terms of text, is integration. So integration is basically that. It's when the new owners take over, and how is that company now going to function without, you and the other folks involved? And how's it going to be effective? And it's so key and so important because the buyer has paid all this money for this company, and they need to now realize the value of it. So, obviously integration is beyond the scope of this conversation, but, going all the way back to the sort of preliminary stage, you need to be thinking of integration, and who you're going to bring on board and when they'll know that there's going to be potentially a deal done. All of those things are super key. So let's move on to some common pitfalls. I'll spend just a moment on that, and then we'll start taking some questions, and then we can go from there. So mentioned this one earlier. Bankers agreements or financial advisor agreements are generally negotiable. It's fantastic. You should spend some time. You should work with your attorney who's experienced the area, help you negotiate that. Other common deal pitfalls, again, The letter of intent sets the stage for the rest of the deal. You got to negotiate those key terms sooner rather than later, and you got to be okay with, if the deal doesn't get done because you can't get the LOI in place, better to have that deal fail fast than, getting into the thick of it and then deciding you want to break up. Um, the other issue is not having fully, okay, so this comes up more in the um, diligence phase, but not having had fully executed written agreements with your employees and other contractors, not just contractors, but your other contracts. I mean, if you have the right to use 10,000 square feet of space, but you don't have a written lease, the buyer is going to want to he's going to want to know, he or she is going to want to know, what the terms of that are, and feel comfortable that the day when they take over, rent isn't going to increase 10x. So having all those agreements in place, having your corporate books and records, the people who have stock actually have stock. It's not just promises to your brother Harry and Sally and this guy who helped work on a mural. You want to make sure those people actually are part of the written records. And then acting as your own legal counsel or hiring the wrong attorney or shop to help you out is always a disaster. And one of the things that I think that we're really good at is M&A events. But the other thing too is we're pretty good at cleaning up other people's messes too. So we get a lot of that work. We'd rather have people get it right the first time, but sometimes you're dealt the card that you're dealt the cards that you got. So with that in mind, I'm going to move to some questions. But before I take any questions, I first really want to thank you for attending. It is, as I said, this is the first time doing this presentation here. I hope it went smoothly. I think it did. We've set aside some time. We're going to take some questions now. We're probably not going to get to all of them. We'll go till, I don't know, maybe 1:15 or so. But if you're interested in chatting with us, we set aside some time on Thursday, Friday, and Monday to talk to people who were in this webinar, and that's going to be from 1:30 p.m. to 3 p.m. Pacific Standard Time. So you can shoot me an email at jpg@putnamgordon.com. Alan, who's listening in, will help schedule you, and I'd be very happy to chat with you and see whether or not we'd be a fit, or kind of expand upon some of the things that I talked about today. Again, what we talk about would not be legal advice. I'd just be giving you some general information for how these deals are done. So I'm going to actually move this over to my favorite picture to show you guys that I do skydive. And I'm now going to take a look at some of these questions. All right, so will the slides be available somewhere? Yes, you can download them because they're in the handout, and then they'll also get posted on our blog. And then we have a question. You mentioned that startups usually wait to a later stage to hire lawyers. This usually happens because founders know they're unable to hire lawyers before being funded. How do you propose startups circumvent the chicken and egg situation? How do you suggest hiring lawyers pre-funding? I think that is an excellent question. So, yeah, I think that reflects what the actual problem is. We try to be flexible with our clients. We have some packages, which I'm not going to get into, to deal with the really early stage stuff to get them sort of at least set up properly, and to help sort of nurture them along. And that's how we try to address the question. But it is difficult. I mean, bottom line is, and I deal with this too because I started my own practice and I started with no clients and nothing. Both your time and your economic resources are finite, so you got to allocate them to where they're most efficient. And I respect that. Okay. Okay, we have a question of how this would vary from deal to deal. And that comes in, I'm going to just shorten your name to E. I hope that's okay. E, could you send in and just ask, is there a specific thing that you're focused on, or is there something more, is there something else? Or you're just looking sort of generally? So one of the things that I really love about doing deals is that they are all different. we generally we have sort of a typical client who we work with, which is either an emerging growth company like a startup or what would be considered middle market companies, sort of lower middle market companies, companies earning between, 5 million and let's say 100 million in revenues. But they vary, right? So, whether we're working with like a trucking company or we're working with a VR company or AR or software, um, each deal is a little bit different. And some of the things that come up, especially, on the more middle market side, is what people's motivations are. Okay. Um, if you're a serial entrepreneur in the tech space, that's it. Starting companies, growing them a bit, and then selling them is what you love to do. Okay. And so you're going to be motivated about getting value to, this is not for everybody, but we find that they're motivated to get value for themselves, for their investors, so that they can move on to their next big project, which they'll be super passionate about. If, for example, you're more of a middle market company, you're a guy or a gal who has built something from nothing or maybe taken a family business, there are other considerations, okay? There's family legacy. There's your own personal identity that's sort of wrapped up in it. And getting comfortable with those issues, I think that's one of the things that we do really well with. I think that we do a really good job of listening to our clients and determining what not only the monetary issues that they're facing, but also some of the more core identity issues are. Um, but in terms of other things that vary deal to deal, I mean, this is the basic structure, but everything goes. So some deals are all cash, some are all stock, some are a mix. The respective bargaining powers between the seller and buyer change. Okay, so if you are a super hot startup and you've got offers from many different buyers, that's a fantastic position to be in. But that's it. So, so the terms that you're going to get, right? You may not have as onerous an escrow. There may be no escrow, so that if there are any problems, well, the buyer is willing to sort of take all of that risk. Those types of things all come up. I hope that sort of answered your question. And maybe, are there any other questions out there? Oh, my goodness, there certainly are. Okay. What is the typical time? What is the typical time and how much does it typically cost? Okay, each of those varies dramatically. So, I mean, usually, like probably a super fast deal from, if it is a small company or a company just starting out, you could go maybe from the letter of intent to close in 2 or 3 weeks. That would be exceedingly fast. But if it's a small company, maybe only sort of 2 or 3 founders, and they're doing maybe what's called like an acqui-hire deal. So that's basically like the company that is acquiring them is mostly interested in the talent, that is the people, as opposed to the technology or something. And we see a lot of those. Those can move pretty quickly. The reasons for that is that if there are only 2 or 3 people, there are less cooks in the kitchen and less people you need to sign off and who need to sign off on the deal. Other deals, I mean, honestly, especially the ones that don't take this advice to um, strategically position themselves early on and to make sure that they get everything documented in writing early on and to work with competent counsel early on. There can be a tremendous amount of cleanup that has to get done. And cleanup is always so much more expensive because, typically instead of just having to have, the CEO sign off on something, now all of a sudden you got to get board approval and maybe shareholder approval. And I mean, I've worked on deals where it's, almost taken a year to get done just because there's just been so much cleanup that has to get done. In terms of cost, man, does it vary? I mean, a very small deal might be $10,000, and then it can go up into hundreds of thousands, or the super big deals. I don't know anybody out there who is an SPG member or a Marriott member, but I mean those billion-dollar deals. I mean you're looking at hundreds of thousands, if not millions of dollars in attorney's fees. So I would love to have that deal. I don't think that'd be a good fit for us, though, to be honest with you. But it can really vary in terms of cost. What are your recommendations for qualifying a banker, which is really a financial advisor or broker? getting through. Can you comment on your experiences or observations on this? Well, okay, good question. So there are folks out there who so there are business brokers, and then there are bankers and investment bankers. So I was kind of more commenting on an investment banker, and so there are both very large shops like Citigroup would have an investment banking group, and probably Merrill Lynch has one as well. And then there are boutique shops. So there are shops where there are individuals, maybe two or three guys or gals, and that's what they do. They only deal in, let's say, their specialization is, you know, uh, healthcare, and so they know the the doctors' offices market, or healthcare association markets or hospitals. So there are these little boutique firms out there that do that, as opposed to a business broker who may or may not have you know the may or may not have the certifications and licenses that an investment banker would have in terms of whether it's a Series 7 license with the SEC or being signed up with FINRA. And business brokers are kind of more, I would say, in the small business land, or at least we see them more in the small business territory. So 1 to 5 million companies that are sort of 1 to 5 million or so, and they work kind of more in that market. So that's what I meant about that. I imagine, we normally don't work too much with brokers because we find that their deals kind of are a little bit smaller than what we do. So that's kind of how they fit into there. So someone asked about their startup being based in the UK, and are we able to do our services there? Yeah, so we work with companies throughout the world. And we did a deal with a company that was based in the UK, but they were acquired by an American company. Um, and so a couple things happened there. Typically, I'm not licensed in the UK, so we don't handle the UK law, but we generally find that there are issues that come up. So, maybe the American company will, the acquirer in this case, will want to have the law be in, the choice of law is U.S. law. And so, we work the company to put the deal together that way. Or sometimes the UK counsel needs, um, an American attorney or someone in California to review the deal. Or sometimes there are U.S. subsidiaries of UK companies or other companies. And we work with companies in Switzerland and Germany and Australia and beyond. And so if there's a connection to the U.S. and more specifically California, we can and generally do get involved. But we also are mindful of what we can't do. And so if it's a matter that doesn't involve U.S. and California, we don't handle that. Yes. Okay. So Jim. Okay. And I think that covers everything. I see that there's another C above from Jim, but I think I answered that question. So Jim, if you want to talk more about it, um, set up a time. I'd be happy to do that. And for anybody else who would like to speak some more, I would be happy to chat with you. We can set up a time. So send me an email, jpg@putnamgordon.com. And thanks for logging off, or excuse me, thanks for logging in and attending today. Have a great day. Bye-bye.